Hey there, it's Matthew Thrift again, bringing forth to you the exclusive right to sell listing agreement, SCR form 220 in zip form if you search for it by number. So we know that this document is what allows us as listing agents to represent a seller in the sale of their home when you go conduct your listing appointment. Hopefully, if your seller says move forward, you are going to execute this particular document for that particular owner seller to become your seller client. And the very first portion of page 1 is very self-explanatory. It does not require a whole lot of explanation, but it says in consideration of the covenants herein contained, the seller's name, their full legal name, if you possibly can, or the estate, or whoever the seller is, the entity, the company, the corporation, and then the brokerage. Notice that we have BHHS/CDAN Joiner Realtors. If you work for CDAN Joiner, if you work for another company, obviously it's going to be your listing company or your brokerage name. And then it goes on for the period of time beginning on such and such date. Notice we've got October 29th. Today is October 29th, 2018. And we'll continue on for a period of time. For example, 3, 6, 9, 12 months, whatever the case may be. There's no standard of listing agreement. I guess if there was, it would probably be 6 months. But you don't have to have a 6-month agreement. It would be nice to always have one. But most of the time we do see 6 months, but you can do a 3-month agreement, you can do a 4-month agreement, you can do a year-long agreement. There's nothing stating that you can't. One little thing I wanted to bring out too, when I was in sales and I was doing listings, I would, and again, this is just me, my personal professional opinion, I would always have my listing agreements expire at the end of the month, not in the middle. So for example, if I did a listing agreement on the 15th of this month, and I just wanted to do a 6-month agreement, I would not have it expire 6 months to the day on the 15th of the month. I would drag it out a little bit more to the end of the month. And it was only for sheer purposes of knowing typically at the end of the month I would have to do something with listings that I had. So again, it just makes it a little bit easier to catch up with, and I can log those on the calendar as appropriately as I need to. The next few lines, lot, block, section, and subdivision. Get this information from the courthouse retrieval system. Fill in the subdivision if applicable. Address is self-explanatory. Tax map, make sure that you know which tax map that you are listing, and then the city and the zip, and obviously the county that you're listing in. It goes on to say the real estate described herein includes all improvements, fixtures, appurtenances, and the additional property, if any, described here. So I've put in here, outbuilding and backyard shall convey with the property, or this shall convey, or this particular piece of equipment shall convey. Also, you may want, if the seller does not want to sell the chandelier within the dining room, you may want to put here, chandelier currently located in dining room does not convey with sale. Now, hopefully the seller will change this out prior to the listing and it does not appear in any of the photos and things like that. But if it does, make sure that you have it in your listing agreement that you are in full understanding that that chandelier does not convey. So when you go to put this property in the MLS, you can refer back to this and you just mention that in the multiple listing service that the chandelier does not convey. So again, self-explanatory for section 1. Hope that helps. Let's go on to the next section. Section 1 should look very similar to other sections of contracts. So for example, in the exclusive right to buy, you see this exact same verbiage. Very easy to understand. That top block there discusses the fact that you, as the associated licensee or broker associate, shall at the first opportunity of substantive contact with a customer, that you provide that customer with a meaningful explanation of agency in the state of South Carolina. It also says the word "and" that you will give the customer/client, at this point they're becoming a client, a copy of the South Carolina Disclosure of Brokerage Relationships brochure. So you got to do both. Give them meaningful explanation and provide them a copy. Remember, you cannot force a citizen of South Carolina to sign an LLR document. But on the second page, there is signature of obtaining information or obtaining that document that shows that you have explained it to them and that you've provided them a copy, but it is not a contract. So the second and third line discusses dual agency. That second line says, no, the seller will not allow you to dual agency. Or the third line says, yes, we'll think about dual agency at the time. However, we want to be given that opportunity to say yes or no. So most of the time as a broker, I see that line 3 is initialed by the sellers because they'll think about dual agency at the time. I have seen where some sellers will say absolutely not, I only want single agency, and they'll initial that second line. But again, that's completely and totally up to the seller. So lines 4 and 5 are discussing designated agency and whether or not the seller will allow a designated agent from within the same office that you are listing out of. For example, if I go out and do a listing and another agent from the Simpsonville or the Greer office provide a buyer or bring a buyer, that the seller will allow that. But again, that's at the time that they are going to look at that and decide whether or not they're going to accept that. So the sellers, again, do not have to absolutely say yes or no, they will or will not accept dual agency or designated agency right then and there. If they initial lines 3 and 5, they're saying they will think about that at the time the opportunity is presented. Again, pretty self-explanatory. Let's look at section 2. Section 2 is entitled Compensation to Other Brokerages. Let's read a little bit. Owner acknowledges broker has advised owner of broker's general company policy regarding cooperating with and compensating other brokerages. Here at Tidelands Joiner, we compensate transaction brokers, we compensate buyer's agents. In our policy, we do not compensate sub-agents of the seller. It says owner authorizes listing broker to compensate other brokerages as legally required in the following amounts of US dollars and or percentage of gross sales price. Notice it says gross sales price, not net sales price, meaning sales price after concessions. This contract talks about gross sales price. If there's any deviation from that, you must make that change within the contract. So the lines are pretty self-explanatory here. You've got buyer's agency, a percentage or a dollar amount, transaction brokerage, which is the non-agency, and or a dollar amount, or sub-agency, which you can see I don't like blank lines. That is a pet peeve of mine. I don't believe in blank lines in a contract. So therefore I have NA on every blank line that's not going to be applicable in this contract. Other brokers are okay with blank lines. I particularly am not. I like to see that NA or not applicable put in those blank lines. Other than that, if there's any deviation of what you're actually charging or what you're going to provide, you need to put those in the lines that are pertaining to that particular deviation. I have seen where agents are putting a little bit less percentage within the transaction broker line as opposed to buyer's agent. That is not a preference of mine. As a matter of fact, I do not agree with that. However, please check with your particular broker in charge. I believe our transaction brokers that are bringing a customer should be paid the exact same amount as a buyer agent with a buyer client. However, there's some discussion about that can be completed at another time. But anyway, as a whole, typically we do see these as the same. So let's go on to section 3. Again, pretty self-explanatory. So section 3 talks about the terms of the contract as far as the sales price, the terms about what you as the listing agent are getting compensated for, and that what you as a listing agent are going to offer to a buyer agent and or transaction broker. So again, that top line, a broker agrees to employ broker's best efforts to sell or to secure a contract for the sale of property for a price of blank. And once you start typing that within the zip form software, once you start typing the actual dollar amount in the line just below there, for example, we have $225,000 there. Once you type in those numerical characters, that spelled out amount is going to show up on that top line. And it goes on and says, and in return, owner agrees to pay a broker a fee of blank or a commission of blank percentage. Typically, we do not see a flat fee unless it's a lower price property. So for example, let me give you a hypothetical. When I was in sales, if I did anything below $35,000, which I did a lot of those as being a foreclosure agent, my standard fee on a $35,000 property would be a $2,000 flat fee, and I would accept $1,000 on the selling side, and I would offer $1,000 on the buying side in the MLS. But most of the time we don't see flat fees. We see a percentage amount. Remember, here at CDN Joiner, we have a certain amount that we charge for a listing, and we start out at a certain price, and we can negotiate that to a certain amount without broker approval. And that is that first percentage there. What is the seller paying you as the listing agent? The whole entire amount, the listing commission. Because remember, once you then put that in the MLS is cooperation with co-op brokerages and compensation to co-op brokerages. So you as the listing agent are going to offer a portion of what the seller pays you to the cooperating broker to bring you a buyer. So that first line there, that first percentage, is what is the seller paying you in the full amount. And then the second line, that the owner understand that the broker shall pay the cooperating broker's fee of blank dollar amount or a commission of blank percentage of the gross sales price. That is what you are going to offer the buyer agent. That's what's going to go in the MLS. It says owner and broker agree there shall be no variation or exception in the amount of the fee or commission to be paid unless specified in paragraph 27. The brokerage fee shall be earned, due, and payable when an agreement to purchase, option, exchange, lease, or trade is signed by the owner. Notice it doesn't say closed. It says when an agreement to purchase is signed by the owner. However, if owner shall fail to refuse to sell the described property for the price and terms set forth herein, or if the owner shall fail or refuse to complete the sale of such property under any written agreement to buy and sell real estate to which owner has agreed, broker's full fee shall be due and payable by owner. So it is what I like to call a team effort. You as a listing agent market the property, you present an offer, you get the terms negotiated, an agreement to buy and sell is ratified or executed. If the owner or seller refuses to sell after that point, under contract, you are deserving and owed a full commission from that seller. So please make sure they understand the terms of this contract. On the second page, it says owner agrees to pay all costs, including reasonable attorney's fees, which may be incurred by broker in the collection of the fee by owner under this agreement. So if they default, if they decide not to sell, the contract states that they're going to pay the attorney's fees if you have to go after those. That's very rare. Matter of fact, in my 12 and a half years of doing real estate, I have not actually seen that. I'm sure it's probably happened, but I personally have not seen that. Second paragraph, page 2, broker agrees to defer the commission until the closing date, which is the typical reason why we get paid at closing, or extension thereof stated in the agreement, or until default by the owner. So just because we provide an agreement to buy and sell doesn't mean we're owed anything. Most of the time, per the contract, we're not going to get paid when the agreement is signed until closing, because that's exactly what the contract is stating. Deferral is agreed to solely as an accommodation to owner, and such deferral shall in no way be construed as a waiver of the brokerage fee. Closing attorney is hereby irrevocably directed to deduct and pay said broker's fee from the proceeds of the sale. So when they have the equity of the house when they go to close on the property, the commission is deducted from the equity of the house from the seller. That's all that's saying. That third paragraph there, if the property is sold within a blank days, and I just put 90 there as just an example to show you, 90 days of the expiration or termination of this agreement, which shall be the protection period, to a buyer to whom the property was shown by owner, broker, another broker, or any other person or firm during the term of this agreement, broker's full fee shall be payable by the owner. Now, if that owner terminates the listing agreement or it expires and then re-signs another listing agreement, unless you provide that owner a document that shows those particular buyers that showed that property, the next line is very important. It says the protection period shall be terminated if owner enters into a listing agreement with another broker during the protection period. So if they decide to relist and somebody that was shown that property goes back to it and buys it after the expiration of your listing agreement, your protection period becomes null and void. Now, I've not seen this in court precedent where a buyer looked at a property during one listing agreement and then came back in another listing agreement to find out if that first listing agent was ever compensated or not. I am unaware if that's ever happened. However, this particular contract is very particular when it comes to that agreement either being terminated or expired. If the seller relists, the protection period shall be terminated if owner enters into a listing agreement with another broker during the protection period. So I don't want to be on that side of taking something to court precedent or the state Supreme Court, so let's just go by what the contract states. Let's now go on to section 4 and talk about earnest money. Section 4 discusses earnest money in the listing contract, and basically what it's saying is that we will hold earnest money on their behalf. The owner authorizes and designates us as the escrow agent or another company as the escrow agent as designated by the sales agreement to accept and hold on behalf of owner any earnest money or escrow deposit made in accordance with the terms of any agreement to buy and sell real estate for the property. So, and then it goes on, in the event of default or forfeiture by a prospective buyer, owner will reimburse escrow agent any fees incurred by the escrow agent, including attorney's fees, as a result of the release of payment to owner of any of the earnest money deposited, and such reimbursement may be made by broker from the earnest money deposit. All earnest money will be deposited in escrow agent's escrow account. So then the next paragraph is really bold. It says, owner understands that under all circumstances, including default, broker will not disperse earnest money to either party until both parties have executed an agreement authorizing the disbursement or until a court of competent jurisdiction has directed a disbursement. So what will happen, many times a seller will refuse to sign the disbursement agreement because they think the buyer should have went through the sale, that they don't really have a legitimate reason to get out of the contract. Or vice versa, the buyer will refuse to sign. Well, this document clearly says, and it's by state law, we as the escrow agent cannot and will not disperse funds unless a disbursement agreement is signed by both parties agreeing to how the earnest money is to be dispersed. It will sit in our account until both parties agree where it's going to be dispersed. We have no authority under state law to disperse it without both parties agreeing where it's going to go. So please make sure that your sellers understand this, that just because they refuse to sign doesn't mean they're going to automatically get the buyer's earnest money, because they're not. It's going to sit there until either we get an agreement by both parties or a court of competent jurisdiction, either through regular court means or through interpleader means, decide whether or not which party is going to get that earnest money. Let's go into Section 5. Section 5 is really short and it discusses signs. So basically all it says is that the owner grants to broker the exclusive right to display for sale signs under contract, sale pending, or other similar style signs on the property and to remove other such signs. So I guess if there was any other signs on the property that were in any way marketing the property, that the owner is going to grant the broker / listing agent to remove any other such signs. But not a whole lot in that section. Very easy to understand. The seller is giving you permission to put a sign in that yard, which obviously is where we get a lot of our incoming leads from. Yard signs still are a major lead generator and shows the power behind a listing when you have that sign in the front yard, because it is seen by so many people. So obviously we want as many signs in yards as we possibly can. So again, the seller just gives us permission to put that sign right there. Let's go on to Section 6, talk about our duties as a broker and agent. Section 6 discusses brokers' duties, and in so many terms, it basically says that you're going to employ your best efforts to bring about the consummation of a sale and closing of the property. It says broker's efforts shall include directing efforts of the broker's organization to bring about the sale, advertising the described property as broker deems advisable, and those advertising media of merit customarily used in the area. In other words, advertising on any form that is typical or appropriate for how we advertise here in the area of the state that we do. For example, Facebook, MLS, magazines, any other type of internet marketing, postcards, you name it, it's standard pretty well across the United States. Let's go on. Owner understands that broker makes no representation or guarantee as to the sale of the property. Obviously, we cannot see into the future. We are hopeful whenever we sign a listing agreement that the property is going to sell, but we as a whole cannot guarantee the sale of a property unless you have a guaranteed sales program, which there are some of those across the state. However, that's a whole another kit and caboodle that I'm not going to get into on this particular video. But you as a whole, when you're signing a listing agreement, cannot guarantee the sale of one's property. And it says, that the owner understands that we can't guarantee the sale of a property, that we're going to employ our best efforts to bring about the sale. It says, upon termination or completion of this agreement, broker shall keep confidential all information received during the course of this agreement, which was made confidential by written request or instructions from the client, except as provided for under South Carolina law. So even though the contract terminates, you should, and what by contract says, if the seller asks you to in writing, however, I'm going to go above and beyond that and say, if the seller told you something and you have the wits about you to know that it should be kept confidential, you should be keeping information confidential as a former or past client under ethics. So I believe that explains broker's duties. Let's go into Section 7. Section 7 is probably the hardest paragraph in the entire contract listing agreement to explain. This probably looks very familiar to you. It's also within the exclusive right to buy contract. I'm not going to read the entire thing. Basically, what this paragraph says, that you as a listing agent, we as a listing broker, our brokerage are providing services and benefits to our client to bring about a sale, which brings value to that particular client. It says that if we as a listing brokerage or you as the listing agent do something by error or omission without willful and wanton disregard or intentionally doing something wrong. So, for example, you make a mistake. Something happens and the seller finds himself in a loss of something. That if the seller decides to take you to court and sue you for doing something wrong, this particular contract is the limited liability or limitation on you as the listing agent. It basically says that the seller, if they're going to take you to court and sue you, that they are going to pay your attorney's fees and that they're only limited to what you as an agent would have made under this agreement and what you have said that they were going to pay you if they brought about a sale. So for example, if it was a 6% or 7% listing and they could charge up to that amount for if they were going to sue you, that's what you would be obligated to pay. So it's limited to what you would have typically made. Most of the time it's going to be half that anyway because another co-broke agent would be bringing that. So, but it could be up to the amount that you were going to charge and you were going to make to begin with. That's the limitation of what they could sue you for. Now, if you decide to go out there and be rogue and do something with willful and wanton disregard and intentionally doing something wrong, more than likely that's going to be a crime. This particular limitation basically goes out the window. You could be looking at a lot more worse charges if you do something with willful and wanton disregard for breach of contract. Owner will indemnify and hold harmless and pay attorney's fees for broker from breach of contract any negligent or intentional acts or omissions by any parties, inspectors, professional service providers, contractors, etc., including any introduced or recommended by the broker. Owner agrees that there is valid and sufficient consideration for this limitation of liability and that broker is the intended third-party beneficiary of this provision. So basically, if an owner seller decides to sue you, they're limited to what you were going to make and that they will hold you harmless from anything that a third party does that you recommend. Hopefully that explains it. Remember, again, I'm not an attorney. I'm only looking at this and explaining what I feel is the intent behind this particular contract. However, if you have any more questions on this, please contact our state association or your particular broker. I'm explaining it to the very best of my ability as a non-attorney. So hopefully that helps. Let's go on to Section 8, talk about owner's duties. Section 8 talks about owner's duties, and I like to tell sellers when I was doing listings that this is a partnership. We are a team to work together to bring forth the sale and closing of their property. It lists several line items here underneath owners' duties, that which I'm not going to take the time to read every one. They're on the screen. But basically what I want to bring to your attention is the seller here, you need to be very clear. They need to provide as much reliable information to you as possible concerning their ownership and operation of the property and any encumbrances or liens that affect the property. That's A. That's the very first one. We need reliable, up-to-date information on the property in order to market it appropriately. To permit inspection, letter C, and showing of the property by brokers or brokers' agents, to cooperate with the scheduling, to not stop people from seeing the property, and to not stop inspections from happening because everything becomes time is of the essence, right, according to the agreement. Section E there, to permit broker to incur or pay on behalf of the owner reasonable expenses for repairs, and it goes on there. So I like to look at Section E is if you have an out-of-town owner and they need you to cover costs such as having the yard maintained, paying for any utilities, you can designate up to a certain amount of what you'll pay and you'll be reimbursed back by the seller when that time comes, if you need to get the carpets cleaned or the house pressure washed, that this allows you a contract between you and the seller to be able to do that, where it holds the seller accountable for paying you back. Page 3, it goes on with several more line items. To allow the closing attorney to pay the broker's compensation in an amount equal to the compensation provided above, which is on the first page, from owner's proceeds at the time of closing. So it's just talking about everything that the owner is responsible for and authorizing the attorneys to do on their behalf. To convey, section I, to convey marketable title to the buyer in fee simple, fee from all liens except those stipulated herein. J, to authorize owner's attorneys and the settlement agent to furnish to broker copies. It says final HUD 1 settlement statement. I believe there's probably going to be an upcoming change to this where it says the closing disclosure or TRID document, whatever the wording is going to be. We still use the HUD 1 on cash closings. But basically, the owner is saying that we give you permission to give the brokers that are involved in the transaction a copy of that information. And then letter M, let's see, to furnish broker with written instructions regarding the confidentiality of information upon termination or completion of this agreement, which was received during the course of this agreement in accordance with South Carolina law. So if the seller told you something, the seller needs to write it to you to say, hey, you need to keep this particular information confidential, and I'm letting you know, I'm writing it down. I don't want you talking about it even after the termination of this agreement. So a lot of things that the owner needs to do as a team with you to get this property sold. So make sure you go over them and make sure they understand every line item here in this particular section. And again, they're pretty well self-explanatory. Not a whole lot of necessary explanation needs to be done here. So let's go on to section 9, which talks about the seller's disclosure. And let's go now. Section 9 talks about the residential property disclosure statement, and it's a very long paragraph, which I'm going to make very short. Obviously, under state law, a seller is obligated under state law unless they are part of an exemption. So, for example, if this is an estate sale, if it's a foreclosure, if one family member is selling to another family member, so for example, a husband is selling to a wife, that's an exemption. They don't need to provide a seller's disclosure. An estate, if somebody passes away and leaves a property and the new estate owner or representative now owns the property, they don't have to provide a seller's disclosure. What I want to get across here is just because an owner did not occupy a property, i.e. investors are not exempt from the seller's disclosure. I see this time and time again. I'm not exactly sure where this came from, but that is a total false statement. An investor must provide a seller's disclosure under state law. I don't care whether they check no representation or yes or no or not. They have to provide it. If a property is being sold that's not part of an exemption, it must have a seller's disclosure. This is in the MLS rules and regulations, and it's also in state law. And basically, the whole entire paragraph states the following, and they need to present, they being the seller, need to let you and other potential buyers know of any material adverse facts that are a part of the property or that are wrong with the property. They need to be as truthful as possible, knowing that other potential buyers are going to be looking at this document. And they're going to be making determinations on whether to offer on this property based upon the seller's disclosure. So they need to answer this as best as possible. And remember, let me remind you, you as an agent cannot write this on their behalf. You have to provide this document to them, but you can have no say-so within the documents. You're not supposed to answer questions about it. You theoretically can be a scribe to it under state law. You can only be a scribe to write down exactly what they're telling you if that was necessary. However, you should at all possible cost avoid touching this document. Present it to the seller, let them write it, let them answer every question to the very best of their ability. That's what it says, and that's what we need to do. So let's provide those seller's disclosures when they're not under exemption. Let's go on to section 10. Section 10 talks about disclosure. And basically all it says is that owner authorizes broker to disclose information about the property to brokers, agents, sub-agents, prospective buyers, and all inquiring parties. If you know anything about the property, especially material adverse facts, we have to disclose it. We have to let other agents and buyers know if there's material adverse facts about the property. But it's also saying that any other information about the property, the owner is saying that they give us permission to let other people know and prospective buyers know. Such disclosure shall be in accordance with broker's company policy. Owner hereby authorizes anyone having a lien against a property, including the mortgage holder, to disclose complete information about the lien to the broker and to the closing agent or closing attorney or agent. Obviously, when it goes to closing, title search is going to be done. The mortgage is going to be found. Mortgage company is going to provide that information to the attorney. Not really a whole issue, but it's in the contract. So not a whole lot there. Let's go on to section 11. Section 11 talks about taxes, and not a major discussion needs to happen here, but it does talk about the owner and what they agree to. And they agree to comply with the provisions of the state of South Carolina, and it gives the South Carolina Code regarding withholding requirements of owners who are not residents of South Carolina. When they go to close, the closing attorney is going to withhold a certain portion for income taxes. Again, that falls under what the closing attorney is obligated to do under tax laws of the state of South Carolina and under the federal government. It says the payment of rollback taxes, if applicable, and past personal property taxes, if applicable, shall be negotiated between the owner and any prospective buyer. So if there's rollback taxes, if there's any past taxes that are owed, that can be negotiated between buyer and seller. So make sure you look at that, especially if you're buying raw land that's categorized as farmland or agricultural. A lot of times if somebody's going to take that land and build a house on it, there is going to be rollback taxes, and so buyer and seller can negotiate that. So that's what all that is saying. Not a whole lot there, so let's go on to section 12. Section 12 here in the upstate is not really going to affect us as agents very much. If you're looking at this video down in the coastal part of the state, then obviously this section will affect you. However, up here where we're not anywhere near the ocean or anywhere near, most of the time, wetlands, our properties are not going to be affected by this. But let's explain it anyway. In the event the property is affected by the provisions of the South Carolina Coastal Tidelands and Wetlands Act, and it gives the section there, an addendum will be attached to the sales agreement incorporating the required disclosures. The payment of any necessary surveys shall be negotiated between the owner and any prospective buyer. Very self-explanatory. Not going to spend a whole lot of time here, but wanted to let you know that if you're in the south part, or correction, the coastal part of the state, once you get that agreement, there needs to be a coastal Tideland and Wetlands Act disclosure provided with your agreement to buy and sell. Let's talk about the MLS. Section 13, the multiple listing service. This is pretty easy too. Not a whole lot in this particular contract is difficult, but I did want to go over it because there's a lot of questions about this of why do we have two boxes? Most of the time properties go in MLS. That's exactly right. Most of the time they do, but there are certain times where listing agreements are signed and they do not go in the MLS. It's called a off MLS or non-MLS or MLS exempt, sometimes referred to as a pocket listing. Understand, pocket listings are not illegal. Some people think they are, but they are not. According to the National Association of Realtors, they are not. It's the intent behind what the listing agent is doing with that listing. So for example, if an agent was listing a property with the intent to price properties and the intent to get both sides and to withhold it from the market to get both sides of the property, the intent is for the agent, the listing agent, to get that commission. That is when it would be an ethics violation or illegal, so to speak. However, the National Association of Realtors also understands that there are times when a seller does not want their property on the MLS and displayed for the world to see. I always like to give the example if a public figure, let's go with Sylvester Stallone, says, I want to sell my property in the Cliffs, and Sylvester Stallone does not want his property on the MLS, which would then go to multiple other websites, he can elect to have his property MLS exempt. And that would be where the listing agent would then just market it in-house or to other companies off of the MLS, so it does not get portrayed or put on other websites. That's few and far between. Sometimes we have that for getting photos or getting repairs done. There's a certain time for off MLS listing, and then once that is done and the property is ready to go back on the market, we can terminate the non-MLS agreement and then create a new MLS agreement. There's a lot of provisions to that, which I'm not going to go into on this video. You need to check with your broker, because your broker needs to completely and fully understand off MLS listings before they allow this, because there are certain MLS rules and regulations that if you violate, you can pay a huge fine for doing so. So please, I will say this again. If you or your broker do not understand off MLS listings, don't do them. Only do them if you know the ins and outs and the MLS regulations thereof. Please, I beg you. But anyway, let's look at this from we're entering the property on MLS. So it says the property shall be entered into the multiple listing service of which the broker is a member, which shall constitute an offer of cooperating brokerage to all members of the listing service. Owner agrees that broker may compensate any agent representing the buyer from the fee described above. So remember on page 1, that second line there, what are you going to pay the cooperating broker? That's, again, it's backing it up here. So again, shall be on MLS, shall not be on MLS. If you don't understand shall not be, don't do it. Give me a call. Let me explain it. I know it like the back of my hand. But also check with your broker. Some brokers will not allow off MLS listings, so you may want to check with them as well. So again, not a whole lot to say on that. Let's go into section 14 and talk about the lockboxes. Section 14 talks about lockboxes and whether or not the seller is going to allow a lockbox to be on their property or not. Obviously, most of the time, if a property is in MLS, we will go to the property and we will see a lockbox on the property. It's rare that we have a property within MLS that does not have a lockbox, but in certain occasions that does occur. But for the most part, we see that the owner agrees, we see that box checked. Owner agrees for an MLS lockbox to be installed on the property to facilitate showing an inspection of the property. Owner acknowledges and agrees that neither broker nor broker's agents, subagents, or anyone showing the property through MLS shall be responsible for any damage to or loss of personal property or to the realty, except such damage or loss may be caused by negligence of such party. On page 4, it goes on to say, owner further acknowledges that broker nor MLS is an insurer against the loss of personal property and agrees to release the broker and MLS from any responsibility therefor. The way I take this is if somebody, being a real estate agent that has access to the lockbox and allows a buyer in, or a home inspector that has access to a lockbox, or an appraiser, if there's any loss, that the seller is going to not hold us as the listing agency or the MLS liable just because of the fact that the seller allowed a lockbox to be on that property. Obviously, we as the listing brokerage or you as a listing agent or the MLS has no idea whether somebody's going to go in there and do a willful and wanton theft. So therefore, the idea is that the seller is going to hold the listing brokerage and the MLS not responsible for somebody else's actions. That should clear it up. If you have any questions, give me a call, send me an email. It's pretty self-explanatory. Let's go into section 15. Section 15 talks about internet marketing. As you know, that when a property goes in the MLS, List Hub or whatever program is being used, all certain data feeds and RETS feeds and IDX feeds are getting information from the MLS, which is being transferred to multiple hundreds and possibly even thousands of other websites. So once a property goes in the MLS, that property is going to be displayed on multiple other websites. The owner has the ability to say whether or not they want that to happen. Let's look at this in a little bit more detail. It says, owner agrees or does not agree that the listing may be placed in electronic marketing mediums, but not limited to the internet, MLS, internet data exchange, program, or other similar online computer services, and to share listing data, including the property address, with other members of the MLS for marketing and advertising purposes only. Owner further agrees to permit other real estate firms who belong to any listing service of which broker is a member to advertise the listing on the internet in accordance with the listing service rules and regulations. This is what allows other brokerages that do not have the exclusive right to sell listing agreement to advertise and market the property on their website through broker reciprocity. Now, in today's society, it's very difficult to market a property if somebody says no to internet marketing. So most of the time, we're going to see that the owner does agree to allow us to list the property on the internet. But if you have one that says don't do it, then don't do it. You can't put it anywhere. So just want to make that point really clear. Again, not a whole lot to say about that, but just be aware of it. Section 16 talks about other offers. Let's go there now. Section 16, other offers. So it says, owner understands that the broker's responsibility to present offers to purchase to the owner for owner's consideration terminates at the closing of the subject property. That's a pretty well self-explanatory statement there. Or expiration of this agreement, whichever occurs first. So you as a listing agent are not obligated to present offers if you've closed on the property. Wow, it doesn't take a rocket scientist to understand that particular statement. But I had to bring it to you anyway because it's in the contract. So obviously if the contract expires too, you're not obligated to present the offer there either. But it states it in the contract. So there you have it, other offers. You don't have to present them if the property's closed or if it's expired. Section 17, marketing the property. The broker shall not continue to market the property after an offer has been accepted unless requested in writing by the owner to do so. Now, I'm going to give you my personal / professional opinion. I somewhat disagree with this statement. It says the broker shall not continue to market the property. Well, as you know, once the property goes under contingency contract, the property stays on the MLS under contingency contract. If it goes into pending, the property does come off websites and comes off the MLS and goes into a pending status. It stays in MLS, but under pending, so it doesn't show on a lot of the other websites, for example, Realtor.com or Zillow. Listen, my personal opinion, my professional opinion is I would market a property until we are at the closing table, documents are being signed, and the property is fully closed. You never know what can happen on that property until it is closed. At the 11:30 hour, a property that's getting ready to close can be stopped from closing. Don't make the mistake of stopping marketing a property. It is your responsibility as a listing agent to get that property sold. So you need to continue to market that property, continue to provide offers if you get them, have backup offers ready and willing for in case something happens. Again, my personal opinion, check with your broker on that. However, to me, better to be safe than sorry. Let's go on to the next section. Section 18 talks about commission rates. It says no control of commission rates or fees. You should know as a listing agent that every company, every brokerage, every office basically has a policy that states what their commission is going to be. That we as realtors can't get together with other companies to establish a set fee in any given area. That is against the law. We all know that if we are associated licensees. And it just reiterates this to the sellers, that we as listing companies, we as listing agents, we as listing brokers, I don't care whether you're ABC Realty, 123 Realty, whatever it may be, we cannot get together to control what we as agents charge. It's completely and totally up to the listing brokerage of what is the seller is going to be charged. The MLS doesn't control it, nobody controls it. Just be sure to get that across to your seller, that there is no standard, I don't like the word standard fee. The fees are all different, all shapes of life, all walks of life, all listing agreements are different. Make sure you get that point across. I don't think I have to say anything else about that. I think it's pretty well self-explanatory. Let's go on to section 19. Section 19 talks about maintenance of the property. And there's some things in here that I really want to point out, especially if you are an agent that was pre-January 1st, 2016 agents in Greenville County, or that used to go by the Greater Greenville Association of Realtors contract for sale. Because when the agreement to buy and sell came out and appliances and windows were removed from the repair procedure, there was a little discontentment with agents and with how we were handling the repair procedure in regard to appliances and windows. So I wanted to bring a few things out that may help you and your listing agreements to help you and to help sellers take care of things up front as well of what their obligations are. So let's read it together. Under maintenance, it says owner agrees to maintain the property, including lawn, shrubbery, grounds until the day of closing or possession, whichever occurs first. Owner also warrants that all heating, air conditioning, electrical and plumbing systems, as well as built-in appurtenant equipment or appliances, shall be in operative condition on the day of closing or possession, whichever occurs first. Unless otherwise agreed herein, owner shall deliver the premises to the buyer with no, listen, broken panes, broken window panes. It says the owner will not sell the property with broken windows. Right here in the listing agreement. It says they won't sell the property with any torn or missing door screens or window screens, and with no missing or broken hardware, lighting, or plumbing fixtures. So what happens? We totally overlook this particular paragraph when we're listing the property, and the sellers don't do anything to the property, but yet the agreement between you and them says that they're not going to sell a property like this, that all these things should be taken care of before we list the property, but yet we overlook this. So let's be more cognizant and diligent as listing agents to point this out to our sellers, to say, hey, Mr. or Mrs. Seller, there's a broken window pane in the master bedroom or in the kitchen. Let's get that repaired. That plumbing problem, or the hardware here, or the stove that's not working, or this, or you say that AC is not working properly. Let's get those things repaired before we sell the property, because it says it right here in our listing agreement. We want to put forth the best efforts so that these little things don't hold us up when we get a contract for sale. The listing agreement is trying to do that for you. Go by what the document says, and let's get the sellers to do these things up front so that there's not a problem on the back end. I hope that helps. Make sure you bring it to your seller's attention. Let's go on to number 20, the agreement to sell. Number 20, the agreement to sell, talking about the South Carolina or the contract for sale agreement between the buyer and seller. It's just basically stating when the buyer is found for said property, the property that you're listing, the owner shall enter into a written sales agreement which will contain the terms and conditions of the sale, customary provisions as to the examination of title, the curing of any defects in the title, the proration of taxes. Remember, the seller is responsible from January 1st up until the date of sale, and then at a closing date till the end of the year, the buyer is responsible for rents and applicable property expenses. So again, not a whole lot here, but it's just letting the seller know up front, there's going to be another contract. It's the agreement to buy and sell. My personal opinion, go ahead and provide the seller the contract for sale so they can begin looking it over. Maybe even set up a time to go and speak with the seller about the contract. So when they do get an offer presented, that they've already seen it, you've already explained it to them, then all you have to do is go over the terms of the contract so you get things done in a timely and orderly fashion. They've had time to look at it, they've had time to understand everything, and then all you're doing is talking about the terms of the contract. It makes it so much easier for everybody. Just let them know an agreement to buy and sell hopefully is coming, but remember, before it says it's not guaranteed. But let's try to get everything done as much up front as we possibly can. Let's go on and talk about number 21, lead-based paint. And for the most part, we know about what's getting ready to come up on this one. So let's talk about it. Section 21, the lead-based paint section. I'm going to put this up on the screen because I want to read this because I want to be very specific. This is a federal document that we're talking about, the lead-based paint disclosure. It's not some local document. It's the federal document. One thing that I tell everybody, one of the rules of life that I live by, I don't mess with two things. I don't mess with nature, and I don't mess with the federal government. And so when it comes to the lead-based paint disclosure, this is a very important document that a lot of people don't think is really important. But let's put this up on the screen and let's read it. It says, for dwellings built before 1978, I'm going to go on record and say as a broker, if it's built in 1978, I still want to see a lead-based paint. I don't care if it says before. If it's built in 1978 or before, I want to see a lead-based paint disclosure because lead-based paint was still in circulation out there in the market in 78. So for dwellings built before 1978, and as required by applicable law, a disclosure of information on lead-based paint and lead-based paint hazards, the disclosure must be signed by the owner and attached to this agreement, which says it's going to go along with the listing agreement. So it's going to be uploaded into the MLS. It's a required document. Owner represents that either, number one, the improvements on the property were all constructed after December 31st, 1977, or the disclosure has been fully completed and is attached to this agreement. Owner agrees to provide broker with any such information or reports as may come to the owner's possession during the term of this agreement. Owner acknowledges that broker has informed owner of the owner's obligations to provide a buyer of the property with the pamphlet Protect Your Family from Lead in Your Home, to provide information to a buyer of the property with copies of all available records and reports with respect to the property and lead-based paint hazards, all pursuant to 42 U.S.C. Code 4582 amended. That is a federal statute. So why did I do that? Because it's a federal law. Live by the philosophy, don't mess with the government. Make sure this form is filled out. It's signed by you as the listing agent. It's signed by the buyer's agent. It's signed by the seller. It's signed by the buyer. And it's initialed in all applicable places. One thing I don't want to happen is I don't ever want myself or anybody that I work with or anybody that has a realtor's license to be set up on some federal court over this particular document. Don't do it. Take it serious. It's federal. Let's go on to Section 22, mediation. Section 22 talks about mediation between the listing agent and the seller. So if the seller feels that you as a listing agent or us as a listing brokerage has done something wrong, that they will take this and try to settle any disputes through mediation. A lot of times this can be done at the local level. If you're a member of the Greater Greenville Association of Realtors, there's an ombudsman there, and so they can submit that to mediate any problems. Sometimes, though, we have sellers that they're just going to not do that, and they're just going to contact an attorney for litigation. Hopefully we will avoid that at all costs, but it does talk about going to mediation first under the dispute resolution system of the National Association of Realtors. So we want to let them know that they being the sellers, have a chain, so to speak, that if we do something wrong, that they can go through to mediate the problem. I did want to point out at the last portion of this particular paragraph, it says this mediation clause shall survive for a period of 120 days after the date of closing. So property closes. If the seller feels you've done something wrong, they have up to 120 days to file a mediation claim against you. So wanted to let you know about that. Let's talk about some of the reasons why they could mediate. It says a couple lines down, disputes shall include representations made by the owner or broker in connection with the services to which this agreement pertains, including without limitation allegations of concealment, misrepresentation, negligence, and or fraud. Any agreement signed by the parties pursuant to the mediation conference shall be binding. So there is a resolution dispute system by our National Association of Realtors. It can be followed. We just see the local association first. If it can't be handled through the local association, it can go to the state. If the state can't handle it, it can go to the national. So just want to let them know that's the provisions set forth herein for them and also for you as the listing agent. Hope that helps. Let's go on to the next section. Section 23, fair housing. We don't really have to spend a whole lot of time here. This is extremely self-explanatory. And if you're a member of the Association of Realtors and the National Association of Realtors, you know how fair housing is taken federally and what you as an agent must do, that you do not discriminate in any way, shape, or form on fair housing. So it says, owner and broker agree that this property is offered without regard to race, color, religion, sex, handicap, familial status, or national origin, and is listed in full compliance with local, state, and federal housing laws. If you're unfamiliar with the federal housing laws, please do yourself a favor and familiarize yourself with them. Simple Google search will help you with that. So just, it says it in the contract, be aware of it, don't discriminate, make sure that you are fulfilling your federal housing laws. Hope that helps. 24, facsimile. Yes, we are still using the word facsimile, even though most people don't use facsimiles anymore. All this chapter or this section is saying in section 24 is that anything that is hand signed, faxed, digitally signed, whatever signed, okay, it's still legal and binding. The days of having to have things signed in blue ink to be legal are now null and void. If it's signed digitally or fax signed or whatever, it's still legal and binding. So just be aware of that. You don't need absolute original signatures on a document for things to be binding or communicated. Number 25, enforcement. This is protection for us as the listing agents or the listing broker. It says the parties agree that broker may take action to enforce this agreement or collect any associated costs, fees, and damages. Owner agrees to reimburse or indemnify or pay all broker costs in enforcing this agreement or collecting costs, fees, and damages, including any incidental expenses or attorney's fees. So this is a legal and binding document, and you as a listing agent do have the authority to enforce it, and that the seller may have to pay fees in order for you to enforce it. So don't just think that it's worthless. You do have some rights here, and Section 25 does help you enforce the rights of the contract. Section 26, talking about the sex offender / criminal information. This particular section should look very familiar as well because it's also in the buyer's agency agreement. It says that the seller agrees that broker is not responsible for obtaining or disclosing information in the South Carolina Sex Offender Registry, and no course of action may be brought against the broker for failure to obtain or disclose sex offender or criminal information. Obviously, if this is occurring in a particular area, this can affect a seller. However, the state in this document specifically says that we're not responsible for obtaining or disclosing it in any way, shape, or form. If the seller wants to get this when they go to put their house on the market, we should advise them to contact their local county sheriff's office to get that information. But we are not going to do it. We're not going to obtain it. We're not going to disclose it, because that's what this document says. It goes on to say, the seller agrees that they have the sole responsibility to obtain their own sex offender, death, psychological stigma, clandestine laboratory, and crime information from sources, for example, law enforcement. The seller may obtain information about the sex offender registry and persons registered with the registry by contacting the local county sheriff or other appropriate law enforcement officials. So again, leave it to the seller to do this if that's important to them, which it's important to a lot of people. So leave it to the seller to do it. Don't do it yourself. You're not responsible for it. As a matter of fact, stay clear from it. My professional opinion. Section 27 talks about terms and conditions, and it's blank. Obviously, there's just blank lines there. So if you need to write anything in the agreement that is related to your listing agreement, for example, let's maybe you're going to do an agreement that if you sell the property under dual agency, that your commission may be adjusted, and that's going to go in MLS regarding variable rate commission. You may want to write that there if you choose to do so. And any other conditions that you may think about. I mean, things come up all the time that some people just want this to be as a term or condition of the contract. So you could write that in there. This form allows you to do so. Not a whole lot to say about that. Obviously, it's blank, but use your own imagination with what can be written in there. On the rest of page 5, you see this large bolded paragraph there that simply says, the undersigned hereby warrant that they own the property and or they have the authority to execute this agreement. This is a legally binding agreement. Owner shall seek further assistance if the contents are not understood. Owner acknowledges receipt of a copy of this agreement, look at here, and a copy of the South Carolina Disclosure of Real Estate Brokerage Relationships form, again reiterating what's on page 1. Owner agrees to receive communications from the broker at the email address, phone number, and fax number listed below. Then it goes on and it says the owner's signature, date, time, email, phone, fax. There's a witness line there that I as a broker don't need, but the line is there if you wanted to do that in the witness date and time. So have both sellers or however many sellers sign the document. But I also wanted to bring forth to your interpretation and understanding that if you are a Greater Greenville Association of Realtor member or another member of another MLS, make sure you know the rules of entering the property into the MLS and the time frame therein after this document is signed. And the Greater Greenville Association of Realtors, as of right now, today's date, there's a 48-hour time frame that once this document is signed by the seller, it needs to be in the multiple listing service. No questions asked. If you are not going to list the property in the multiple listing service within that 48-hour time frame, you need to either input the property as temporarily off the market, or you need to discuss with your seller and possibly your broker about the possibility of signing the listing agreement to be a non-MLS or MLS exempt listing until the time you can get it into MLS. Don't want to go into a whole lot about that there, but if that ever comes up and you cannot get this property into the MLS within a 48-hour time frame, please talk to your broker, talk to your seller, and there's other options and opportunities that you can do and take, and actions that you can take to help the seller in this time frame, and they also can help you to make sure that you're sticking with the rules and regulations of the MLS. Okay, you cannot put in stipulations property to be in the MLS within so many days of listing or signature. You can't do that. You can't override the MLS. Once they sign on this document, you have 48 hours from the time of signature. So make sure that you follow the rules accordingly. Underneath the seller's signatures, you have the owner's mailing address, if it's not the same as the property that's being listed. And then you have the real estate firm that's listing it, that's self-explanatory in the number, and then whoever's listing the listing agent to sign date and time as well. Just want to make mention that at the bottom of each page, other than page 5, there are initials to be initialed by the seller and also by the broker or associated licensee that's doing the listing. Please make sure that those get initialed on every page as well, just so you have a fully executed contract. Let me go back and say this, that if there's any blank lines, remember that's a pet peeve of mine. I don't like blank lines. Use NA whenever possible. Check with your broker on how they want to handle that. And if there's anything that I have said that's not an exact, what you think that this says, please make sure that you check with your broker in charge or the South Carolina Association of Realtors. Again, I'm not an attorney. I am interpreting this contract the way that I, Matthew Thrift, interpret the contract, and through discussion and experience with the South Carolina Association of Realtors legal team. But because I'm not an attorney, I cannot interpret this contract by law, because if this ever went into a court of law, I am not an expert witness, so to speak, on this particular document. I did not write it, so therefore speak with an attorney, speak with your broker, speak with the South Carolina Association of Realtors if you feel that I've said anything wrong or that's contrary to what the document says. Remember in my disclaimer, I try to do everything and say and teach everything appropriately, trying not to dissuade or persuade anybody to do something that's not in accordance with what this document says. Okay, not an attorney, real estate broker, putting together this video to help each and every real estate agent out there with the listing agreement form 220 as put out by the South Carolina Association of Realtors. I hope it helps. Until the next video, take care. Have a great rest of your day, and look forward to meeting you around the real estate corner soon. Bye-bye.